On January 1, 2025, technical amendments to the Uniform Commercial Code, UCC, took effect across several international jurisdictions, amendments that altered the very definition of ownership for financial assets. Most investors believe that when they buy a stock or deposit money, they own that asset. However, legal documents from the Depository Trust and Clearing Corporation, DTCC, reveal a starkly different reality. You are not an owner. You are an entitlement holder. This is not mere semantics. It is a legal classification that places you at the very bottom of the creditor hierarchy. In the modern financial system, all stocks and bonds are held in pooled electronic form. The original legal title is held by a central institution, and what you possess is merely a contractual claim against your financial intermediary. In 2025, reports from the Financial Stability Board, FSB, showed that the volume of pledged financial assets globally exceeded $100 trillion. The danger lies in the fact that these assets, which you think you own, have been used as collateral by banks and brokers to borrow massive sums. If the intermediary fails, the law grants the secured creditor the right to seize the assets first, leaving entitlement holders, you, to face bankruptcy proceedings that could take decades. The term you must understand now is rehypothecation. In 2024, data from major Wall Street investment banks revealed that client assets were being repledged at rates as high as 140%. This means the stock you bought was used as collateral for loan A, then lender A used it as collateral for loan B, and so on. This chain of obligations has created a terrifyingly fragile system. In 2025, as interest rates rose and markets fluctuated, margin calls began to escalate. The problem is that the physical collateral available covers less than 1% of the paper claims. When the major crisis hits, central clearing will be triggered. This system was designed to ensure the entire banking system doesn't collapse, but the price is your assets. The law protects systemically important financial institutions, CCPs, and allows them to absorb available collateral to cover their derivative losses before you can ever access your account. In March 2025, we witnessed a live trial of what could happen. A major European bank faced a sudden liquidity crisis, and instead of a taxpayer-funded bailout, a bail-in was triggered. Under the Bank Recovery and Resolution Directive, BRRD, a portion of large depositors' funds was converted into equity in the failing bank to boost its capital. The numbers indicate that bank deposits globally are no longer treated as bailments, safekeeping, but as unsecured loans granted by the depositor to the bank. The moment you deposit your money, the law stops viewing you as the owner. The bank becomes the legal owner and you become a mere creditor. What official reports hide is the existence of automatic stay provisions. In the event of a financial panic in late 2025, regulators possess the legal authority to freeze withdrawals and transfers for days or weeks to protect the system. During this period, a forensic audit of collateral will be conducted, and available assets will be allocated to major creditors first. Why is the world rushing toward CBDCs in 2025? The answer isn't technical efficiency, it's the final locking of the system. Central bank digital currencies are the perfect tool for executing the great taking. In the current monetary system, you can withdraw cash and keep it outside the banking system. But in a CBDC system, your money is just a code in the central bank's ledger. The technical data for these currencies shows they are programmable. This means authorities can place restrictions on what you can buy, where you can spend your money, or even impose an automatic negative interest rate to deduct part of your wealth to force spending. In October 2025, central banks began tightening the noose on decentralized cryptocurrencies and physical gold through anti-money laundering (AML) legislation. Through the numbers, the goal is clear: to force all private liquidity to remain inside the digital prison where it can be confiscated or reset at the push of a button during the next financial collapse. The cold truth we reveal at the Shadow Vault is that the laws enacted after the 2008 crisis were not meant to protect you. They were meant to ensure the system would not collapse at the expense of the elite. When you read the annual reports of institutions like the Bank for International Settlements, BIS, you find constant talk of systemic resilience. This resilience simply means the ability to sacrifice small entitlement holders to save the core. The painful awareness is realizing that you live in a rental system, not an ownership system. You rent the right to access your money, and you rent the right to trade your stocks as long as the system functions. But at the moment data collides and collateral deficits occur, you will discover that you are an unsecured creditor at the top of a mountain of debt. Statistics show that 95% of the population is unaware these laws exist. But history teaches us that ignorance of the law does not protect from the consequences. When the value of financial derivatives exceeds $2 quadrillion, $2,000 trillion, which is 20 times the global GDP, mathematics tells us that taking is not just a possibility. It is the only way to balance the books in the final accounting.